Well, good evening, ladies and gentlemen. We're so glad to have you here. This is the fifth program that we have presented by the W. Homer Drake Jr. Georgia Bankruptcy American Inn of Court, and I'm Walter Kelly, the counselor to the inn. To begin, special recognition goes to Judge W. Homer Drake Jr., the eponymous founder of the inn. And also a special thanks to all of the judges who have come and participate with us today. Special thanks also to my friend Anna Humnicki, who used to be Judge Laney's law clerk back in the day and wrote some great opinions. But we do want to thank Anna for producing and directing this program. And also to my friend Gus Small, we've already been telling stories for his presentation this evening. But let me remind you, our final program is the annual dinner meeting that will be on Friday, June the 14th, 2019, at Idle Hour Country Club in Macon. If you want to play golf, Judge Smith says that's fine. He will be glad to get up some golf for us, and we do hope to see you there. Now, Anna, thank you.
Thank you, Walter. For many of you in the room, I don't think Gus Small needs an introduction. To all of you, I apologize. You're going to have to give me a few moments to let me indulge myself in Gus. This is my first chance to ever introduce him. For those of you who don't know him, I wanted to introduce him because he's been my mentor for 15 years, and he exemplifies the core values of this organization, the Drake Inn of Court, which are professionalism, ethics, civility, and legal skill. Gus hails from Macon, Georgia. After earning his undergraduate degree at Emory University, he attended the Walter F. George School of Law at Mercer University, where he graduated second in his class with honors. Upon graduating from law school, he served in the U.S. Army as an Army Ordnance Corps officer and had an ending rank of first lieutenant. He served in Vietnam, and during his tour of duty, he was certified as counsel as part of the Judge Advocate General program. Once he was discharged from the Army, he returned to Atlanta, where he joined the law firm of Lipschutz, Macy, Zusman, and Sykes as an associate. You're going to hear more about his time at the Lipschutz firm during his presentation, and that's where he began his career in bankruptcy, law, and commercial litigation, where he quickly became a partner. In the early 1980s, he started his own firm, which was originally known as Small and Stamps, which later became Small, White, and Morani. Karen White is here with us, where he continued to specialize in bankruptcy and commercial litigation, representing all parties to such transactions and matters: debtors, creditors, trustees, committees, just to name a few. In 2000, Small, White, and Morani merged with another firm, which ultimately became named Cohen, Pollock, Merlin, and Small, where Gus practiced as a senior partner until 2018. As many of you in the room know, in April of 2018, Gus and I, along with Brent Herron and Ben Clare, formed Small Herron, which is a boutique firm still specializing in bankruptcy and commercial litigation, as well as trust and estate matters. Over his career, Gus has taken the time to mentor numerous young attorneys, which is it's a main focus of this inn. Those of us who have worked with him often called him the professor. Taking advantage of his experience and intellect, we'll wander into his office and ask him a question. We know that this is going to save our client hundreds, if not thousands of dollars. But sometimes we do end up in class with Professor Small, which helps us become better attorneys every day. As a result of Gus's desire to help educate people about the law and the practice of law, he has served as an adjunct professor at Mercer's College of Law. He has guest lectured at Georgia State's College of Law and has lectured at numerous CLEs throughout his career. Gus told me this would happen if I didn't have a podium. Gus has also been active in bar associations and organizations. He was the co-founder and past chair of the Atlanta Bar Bankruptcy Section, a past chair of the State Bar Bankruptcy Section. Gus also served on the board of the SBLI, including president and chair, and continues to serve as an emeritus director for the organization. In 2008, Gus received the David W. Pollard Award for Professionalism and Ethics, presented by the Atlanta Bar Bankruptcy Section. It's become known as a Lifetime Achievement Award in the Atlanta bankruptcy community. As Karen White noted today, some sort of equate it with that retirement is on the horizon type award. Little did the bankruptcy section of Atlanta Bar know in 2008, Gus was just getting started. As former Judge Laney law clerk Liz Hall said it best when she found out that I had a job offer in 2004 from Gus and Karen to join them at Cohen Pollock, I had sailed under a lucky star. Jobs at small to mid-sized firms are hard to come by in the first place, but to work for such legends in the industry, I was unquestionably and extraordinarily lucky. Now, 15 years later, I am proud to call Gus not only my former boss and career-long mentor, but he's also my law partner and my friend. One more page. I was delighted when Walter asked me to put together today's program to be able to ask Gus to talk to all of us. I would now like to turn it over to Professor Small, who has promised us an interesting and entertaining conversation about bankruptcy court jurisdiction.
I don't know who you were talking about, but when Anna asked me to talk, to give this little presentation, she said, just talk about whatever you want to talk about. And I said, well, I'm kind of a history buff when it comes to bankruptcy and the Bankruptcy Act and the Bankruptcy Code and so forth. And so I think I'll talk about bankruptcy jurisdiction, and I'm going to compare it to the way it was under the Bankruptcy Act of 1898. And that sounded really dry, so I decided to add a few little experiences to keep you folks awake. But there are a lot of similarities between the 1898 Act and the Bankruptcy Reform Act. So let's get started and let's see if we can plod through this. First of all, is anybody here, I know there are a few, who actually practiced under the 1898 Act? Oh, wow.
Sorry.
This is going to grow, okay. Let's see it one more time. Okay. How many of you never even heard of the Bankruptcy Act of 1898? Oh, wow, that's really some, nobody? Gary, have you ever heard of it? Okay.
Heard of it.
Okay, all right. So what happened in 1898 for Congress to enact the Bankruptcy Act? What happened? Well, there were a few things that happened. One was that Teddy Roosevelt and the Rough Riders stormed San Juan Hill in Cuba. That's one thing that happened. Another thing that happened was that there were some bad economic times. And history, when you look at the previous three acts, 1800, 1841, and 1867, they were all enacted because there were bad economic times. But they were repealed afterwards because people just didn't think there was a lot of morality, doing bad things to debtors and so forth. And one thing was that they never really worked. They certainly didn't favor the debtor. So in 1898, a few of you remember the act, but John Laney and I were toddlers in 1898, and Homer Drake was already on the bench. So that was another thing that happened in 1898. There are, first of all, if you look at the way the act was structured in 1898, and let me jump ahead a few years. In 1938, it was overhauled, but it still was called the Act of 1898, and the amendments were the Chandler Act. So how was this thing structured, and what did the court system look like? First of all, there were, and this kind of goes back to the 1800s before the 1898 Act. There were creditors, unsecured creditors. There were secured creditors to the extent people had secured debt other than mortgages. And they needed somebody, and there was a debtor, and they needed somebody to sort of be the arbitrator between among the creditors and the debtor. This person was called the referee. The referee in bankruptcy was the guy in the middle. To my knowledge, in 1898 and probably in 1938 when the Channel Act was enacted, there weren't any female referees. I could be wrong, but I don't know of. There were not all that many, period. So the court system really was this. Jurisdiction was given, total jurisdiction, pervasive jurisdiction, constitutional jurisdiction was given by Congress to the district judges. So you had something very similar to what we have now. However, there was a section of the bankruptcy code, and by the way, there wasn't a 28 U.S. code section like 1334. This was all in the Bankruptcy Act. And when you look at the Bankruptcy Act, you'll find out another interesting thing if you look at it. It has section numbers, but those do not correspond with 11 U.S. code sections. So when we said section 60 of the Bankruptcy Code, Bankruptcy Act, which was the preference section, that had nothing to do with the 11 U.S. code section. So very, very interesting way that Congress did it. Also, by the way, it was written in a way you could understand it in the old way of writing statutes. And in 1978, when I started looking at the bankruptcy code, what was to be the bankruptcy code, I noticed that this was written in a very different way than I was used to, very different, and somewhat hard to understand. I always found that the Bankruptcy Act was very, very easy to understand. All right, so you had the referee, and the statute actually in Section 38 of the Bankruptcy Act gave jurisdiction. The word jurisdiction is actually used, and it's given to the referee to act in cases where the district court would refer the cases to the referee, kind of like what we have now, except the word jurisdiction is used. Section 23 of the Act, and this one probably of all the sections, other than maybe some of the Chapter 10 sections, is a little difficult to understand. But what the case law says is it separated jurisdiction of the bankruptcy court into two parts. One was called plenary jurisdiction, which means exactly what plenary means, pervasive, all the jurisdiction. And that makes sense because the district court, which was given the plenary jurisdiction, was really the bankruptcy court. And I think that's lost sometimes, and maybe it's lost now. I remember at one convention or meeting, I remember Charlie Seligson saying, and does anybody know who Charlie Seligson was? Oh, come on. All right. So Charlie Seligson was talking about the district court and said, you know, the district court is really the bankruptcy court. And the bankruptcy judge is an officer of that court. In any event, this plenary summary thing worked very similar to what we have core but core is a proceeding, it is not jurisdiction. So if you look at Section 38, you would find that the referee is invested with the following jurisdiction to hear petitions referred to them and make adjudications or dismiss the petitions. Back then, when you filed a petition, you were said to be adjudicated if it was a voluntary proceeding. If it was an involuntary proceeding, you then were at the point that that the involuntary, as we used to say, took, then you were adjudicated a bankrupt. And by the way, the people that wrote the code did not like the word bankrupt, so they changed it to debtor. But back in those days, it was bankrupt. Another thing was grant, deny, or revoke discharges. Confirm or refuse to confirm arrangements. An arrangement was the old Act, Chapter 11, or wage earner plans, and that was now Chapter 13, or set aside the confirmation of arrangements or wage earner plans and reinstate the proceedings, and so forth. One of the things that you can immediately look at when you look at the difference between plenary and summary jurisdiction is summary jurisdiction had really to do with the possession of the race, the possession of the property of the bankrupt or of the debtor. It was a kind of an in rem sort of jurisdiction, and as long as it didn't get past, you didn't have a right to a jury trial, or it didn't get into things that required plenary jurisdiction, the judge could sit on the referee could sit on the case and hear it. When in 1898, the referee in bankruptcy, who is now the bankruptcy judge, got paid out of the estate. So, for example, if the estate, if there was a dispute with a creditor that the referee could hear, or there was some consent to a preference case, and so it was heard by the referee got paid more. The more money that came into the estate. Not a really neat thing to do. He also appointed the trustee or the receiver, as some officers were known. For example, in a Chapter 11, you would be a receiver. But he appointed those officers, and he supervised the case. So this was a kind of this referee was covered a lot of administrative things, and also was a judicial officer and decided cases, although the jurisdiction was limited. This is not this referee system had all sorts of problems. Among the problems were the administration, the fact that he got paid out of the estate, and so forth. In the 1940s, there was a fund that Congress established called the Referee Salary and Expense Fund, where filing fees and so forth were put in, and then the referees were then paid out of that. They were paid a salary. In any event, the jurisdiction of the bankruptcy judge, the referee, was very limited. The jurisdiction of the district court was very pervasive. Now, what did that mean? Okay, you wanted to sue a preference under the old act, worked something like this. You filed the suit in the district court, and the venue was different under the old act. The venue was it was said to be wherever the bankrupt could bring the case. So if the bankrupt could bring a case, it was wherever the creditor was. If the bankrupt could bring a preference case, it was a funny way of saying it. But so if the creditor lived in Idaho, that's where the trustee had to bring the preference case. Couldn't bring it in the court where the bankruptcy was pending. Fraudulent transfer cases, the same way. That was where the venue was. And you had to bring it in the district court unless there was consent that the referee would handle it. All right, so I once filed a fraudulent transfer case trying to get somebody's car back. And I filed it in the district court, and my recollection, I was trying to see if there was any way I could remember where where it was, by the way, the car was worth about $350. And so I filed it in the district court here in Atlanta, and I believe that it was before Judge Albert Henderson, who's passed away. So we filed it, and I can even remember where my office was at the Lipschutz Macy firm. It was in the basement where it leaked, it rained, and the carpeting was wet and all that. But it was right next to the library, and that's where Sam and Morris put me. So that's where I spent a lot of time. Anyway, I filed this case, and right after I filed it, Judge Henderson's clerk calls up and says, "Mr. Small, I just want to tell you that the judge, as soon as this answer is filed, if they file an answer, you'll be on trial in 30 days. And I thought, oh my gosh, I mean, and it's likely to be a jury trial. That was a question whether, did you have a jury trial in preference cases? And so we settled that case real quickly, and I don't know what would have happened if we had to try it. Another way that the referees, now bankruptcy judges, had jurisdiction was by consent of the parties. And back in those days, when John Laney and I were toddlers and finally grew up to be bankruptcy lawyers, there were a lot of, well, let's say there were about 15 in this district, and I don't know how many in Columbus, but in this district, there were about 15 people, lawyers, who practiced bankruptcy law. It was sort of looked down by the bigger firms as the junk business, and so there were about 15 of us who were known affectionately. We thought of ourselves as this, but I'm not sure this was a moniker that was given by I don't think the larger firms who called us this really were trying to do us a favor, but we were called the Bankruptcy Ring. And there were about 15 of us, and so we knew how the system worked, and so we did consent to the referee handling the cases because we knew the referee was a specialist judge and as such would understand what we were talking about. The other way was by implied consent, and that was a very interesting kind of concept. That concept was found in a Supreme Court case in the 60s called Katchen versus Landy. It was a very interesting case. I believe it was a plurality opinion, but in that case, the creditor who got sued for the preference filed a proof of claim. And the bankruptcy judge the referee said, thought, well, in order to decide whether, and by the way, it was an objection to the claim was filed and a counterclaim for the preference. So the bankruptcy judge determined that in order to decide the issue of whether the objection to the claim was good, he would also have to decide whether the preference was a legitimate claim. And that was because Section 57 of the Act would not allow a claim where there had been a preference received. And that's the same law right now. It's 502D. So that's implied consent. And a lot of creditors fell into that trap until people said, maybe I'm not going to file a proof of claim because I don't want to be sued. All right, so this kind of court system with a little bit of change from the 1940s operated pretty well until the 1971-1973 time frame. Now, a lot of people in this time frame and even before were very concerned about the administrative duties of the bankruptcy court, of the referee, and whether really what we needed was a true judicial officer, somebody who didn't have the administrative duties, and who also also had the kind of status that a judicial officer should have. So in the 1971 to the 1973 time frame, there was good news and bad news. The bad news was that in 1970, the Congress had set up a commission on bankruptcy to review the entire Bankruptcy Act and to recommend changes to Congress. There were some really well-known people who owned the commission. What happened was in 1973, this commission said, okay, we're going to fix this system. What we're going to do is we're going to do away with the whole concept of referees. We're going to do away with all the administrative stuff, and we're going to give the administrative duties to a federal administrative agency. And then we're going to do away with 250 or so bankruptcy judge/referees. And what we're going to do is we're going to set up 50 judges who are not going to be Article 3 judges. They're going to be Article 1 judges. They're going to serve for 14 years. They're going to be nominated by the president, and they're going to be confirmed by the Senate. In other words, very similar to the tax court. And we're going to do this, and that's going to straighten the whole thing out. Well, I'm thinking, and the people that I work for, thinking when we heard about this, that's not going to be good for us. What are we going to do for a living? We're going to have to really enhance the commercial litigation part of our practice, because it looks like bankruptcy is not going to be around. And by the way, those of you who do consumer practice, no consumer practice. It's all going to be in the administrative agency. And there were a lot of interesting comments that were made about that. For example, suppose that the person who wants to file bankruptcy goes to the administrative agency and they've done something really wrong. And they tell this administrator what they've done. Gee, you know, I sort of fool around with my taxes and I didn't pay, I haven't filed any returns in a while, and, you know, I actually robbed the corner store and I didn't report that as income. What happens to that person when the he tells the administrator? Around this time, there was one individual who took a really hard look at the structure of the Bankruptcy Act. And he, interestingly enough, had some pretty powerful friends in Congress and elsewhere. And he took it upon himself to decide that he would do everything that he could to raise the stature of the bankruptcy court and the bankruptcy judge. He also decided that he and his colleagues would do everything they could to do away and get rid of this commission bill. Let's see. I think he's here. Oh, that's Judge Homer Drake. Judge Homer Drake in 1972 and 73 was president of what was then called the National Conference of Referees in Bankruptcy. He lobbied in a way that was permitted by law. He talked to a lot of people. He had a lot of friends in the bar, on the bench, and they all believed what he said and thought this was the best way to get the bankruptcy court straightened out and to do away with the commission. One of the things that Judge Drake did was kind of an interesting thing. He, as president of the National Conference, he arranged to have the annual convention in Atlanta. And one of the speakers at the convention, and I had a couple of years under my belt, but somehow Sam Zusman and Morris Macy allowed me to go to this thing. And I mean, I sat there and all these people that I'd read about, people that wrote Collier, they're all milling around. And Morris was personal friends with Charlie Seelix, and so Charlie stayed at Morris's house, so that was pretty neat. any event, one thing that Judge Drake did, one of his closest friends was a man by the name of Herman Talmadge. He engineered Herman Talmadge, our senior senator at the time, to speak at a dinner for all of the then referees in bankruptcy. And at that dinner, and I don't know where Senator Talmadge got this idea, but nevertheless, he said that he didn't think we need any more administrative agencies. And so having said that, and later on talking to some of his Senate colleagues, that was the end of the commission administrative agency. In 1973, Judge Drake had also been part of the group that got the Supreme Court to promulgate the bankruptcy rules. And it was a tough time getting that through the Congress. If you remember how that works, I guess it works the same way now. Congress has a set period of time during which they can decline or decide that the rule, whatever rules there were, would go into effect. So on the last day, as I understand it, Judge Drake prevailed on mostly what he wanted, and got into the bankruptcy rules a definition which was in Rule 9017, which said that it defined a bankruptcy judge as being as a court of bankruptcy. And so for the first time, bankruptcy judges were, referees were called bankruptcy judges. And that's where the name bankruptcy judge came from, and it came directly from Judge Homer Drake, the guy that y'all named this in after. Quite an accomplishment. I think just to make sure that everybody understands, in the Northern District of Georgia, and as far as I know, all the districts in Georgia, the 3 districts in Georgia, we called the referee judge, and we said, "Your Honor," whenever we addressed the referee, and we stood up. Homer Drake was the first referee, probably in Georgia, to wear a robe in 1964 when he became a referee in bankruptcy. When I started practicing in 1971, when I got to Atlanta, I asked Sam Zusman, "Okay, what do you call the referee?" And he said, "You never call him referee, you call him judge." And there were 3 referees at that time, and that's how we did it. That wasn't the way it was in other districts. For example, you probably heard about Asa Herzog. The name Asa Herzog was a very prominent referee in New York City. The district judges, when they would write on appeals, they would never address him as, or when they saw him in the hall, as Judge Herzog. They would call him Mr. Herzog. And in New York, that's what you address the referee as Mr. whoever it was. All right, so now we had the start of something in 1973, a court that was run under the 1898 Act, had plenary and summary jurisdiction, but thanks to Judge Drake, now this was the individual who was a referee was now a bankruptcy judge. So what happens between 1973 and 1978? Well, a lot of things happen. Congress is debating, and all of us in the bankruptcy bench, all over the bankruptcy bar and the bankruptcy bench, all over the country, are trying to get something that we can, that enhances the status of the court and something that is workable. Judge Drake and a lot of lawyers and a lot of judges thought the best way to do this was to set this court up as something like the Court of International Trade, or whatever it's called, which was an Article III court. It's only other Article III court, not like the tax court. To set this court up as with the judges being Article III judges and the administration being handled by clerks and other officers. That went to Congress, who at the time, there just weren't enough senators who would go along with adding another 250, 200, whatever it was, Article III judges. So what came out of the Congress in 1978 was a bill that did the following. It was very interesting. It appointed bankruptcy judges to handle all of the cases, the bankruptcy cases, and it set up a bankruptcy court. But what it did was it allowed these bankruptcy judges to be appointed by the president and with the advice and consent of the Senate. In other words, almost exactly like the tax court. The second thing that it did was it gave pervasive jurisdiction to these judicial officers, pervasive jurisdiction. In other words, no more plenary, no more summary. You get it all right there. In the bill passed Congress. The last day for President Carter to sign it was November the 6th, 1978. It was the best that everybody could do at the time. Some of us were concerned about whether a judge who's very similar to a tax court judge in a very specialized court could in fact have this kind of pervasive jurisdiction. It passed Congress, and on November the 6th was the last day it could be signed by President Carter or vetoed, or the next day it would become law. I'm going to tell you a story now that probably a few of you may have heard, because I've told it a couple of times, but this is really the truth. It's what happened. November the 4th, by the way, November the 6th, 1978 was a Monday. November the 4th was a Saturday. I happened to be in the office, in our office at Lipschutz Macy. Then it was called Macy, Zusman, and Sykes, because Bob Lipschutz, who was our senior partner, had gone to Washington. He had been had been Carter's campaign treasurer, and he became counsel to the president at the time. So he was in the White House. It was a Saturday, and unfortunately at the time I had to work Saturdays. We all work Saturdays. And Morris came running into my office and in Sam's office. I think actually I was in Sam's office, and he came in, he said, "Y'all need to come into my office. Bobby is on the phone." Okay, so fine. Sam and I went into Morris's office, and we even had back in 1978 the speaker phones, not as elaborate as we have now, but we had them. It was better than a tin can and a string, which when I first started practicing law. But anyway, so Lipschutz says on the phone, this is Saturday before the Monday, he says, the Chief Justice Berger, who was against the bankruptcy code becoming law, but because protocol allowed him to send a direct message, bypassing all sorts of people in the White House, a direct message to the president, he had sent a letter to the president saying that he opposed the bankruptcy code, didn't think that there should be bankruptcy judges that had this kind of jurisdiction and so forth. And Jimmy Carter had written on the letter, "Okay by me," signed J.C. and he sent it to Lipschutz, who was counsel to the president. So the purpose of the call was to ask Morris and Sam, and certainly not me, because as this conversation began to go on, I, as really a junior partner in the firm, I'm gobsmacked. I just, I'm watching history happen in my area of practice, and I was speechless. Morris, so Bobby says, what should we do with this thing? Because he's going to veto this. What are we going to do with it? And Morris said, well, I've never really been in favor of this. I've never been in favor of it, but I'll tell you this, it's been, and we didn't use the word vetted back then, but it's been vetted by lots of people, lots of scholars, lots of people on the bench, and certainly a lot of lawyers. And they all want it, and I think probably he ought to sign it. A month or two ago, I got hold of Sam Zusman, who's retired in Orlando, and I said, Sam, do you remember this? And he said, yes, I do remember it. He said, I remember you being there. I remember Morris and me, and I remember Bobby calling, and I remember the whole thing about Berger. He said, but I just remember that I said that it ought to be, it's a good law, and it ought to go into effect. And he said he remembered that, didn't remember too much of what Morris had said. I remembered what Morris said. I didn't quite remember what Sam said. In any event, sometime between that Saturday and that Monday, Lipschutz apparently got, and I think there were other people in the White House. I think Judge Drake probably talked to some of his friends who were also in Carter's White House, and it got signed on the last day that it could get signed, and it became the law. So now we're looking at really a new way of practicing bankruptcy law, and it was very exciting. It was very exciting for me and all the young lawyers in town and some of the old lawyers. Well, if that was the end of the story, I guess I wouldn't be here, or some of you might not be here, but anyway, or maybe you would be. So 1982 rolls around, and we have a case going to the Supreme Court called the Northern Pipeline case. The Northern Pipeline case was a case involving a lawsuit against a third party. And the question was, did this pervasive jurisdiction that the bankruptcy judges had, was this constitutional? And they held, the Supreme Court said, no, it was not constitutional. It was not constitutional. An Article I judge could not have this kind of pervasive jurisdiction. And they demolished, and I mean they demolished the bankruptcy court. And in 1982, after that decision went into was enacted, came down from the Supreme Court, the court figuring, okay, well, we're going to give a few months. So it came down, I think, in June, and they gave Congress until October to fix it, which, if you know anything about the history of the Bankruptcy Acts and the Code, you will know that none of this, the Congress is not interested really in bankruptcy laws. And as somebody once said, the debtors of the world do not have any lobby in Congress. Creditors do, and credit card banks do, as you can see from 2005. But October came and went, and all of a sudden, there is really no bankruptcy court. They're bankruptcy judges. And the question is, what is the authority of the bankruptcy judge to sign anything? Title companies said, we're not, if a trustee wants to sell property free and clear of liens, forget it. Not going to happen if bankruptcy judge signs it. Got to have the district court. After all, the district court has always had plenary jurisdiction. The district court is an Article III court. So what happened all over the country, I believe the judicial conference and some of the judges here may know the details of this better than I, but somebody wrote up an order that allowed set up a procedure for countersigning orders of the bankruptcy judge by the district judge. And I think there was actually a duty judge that was in the district court that actually, depending on what day it was, would sign off on these orders. All right, for the next several years after that, 2 years as a matter of fact, a lot of lobbying went on. Judge Drake Judge Drake was back on the bench. He had left the bench probably in frustration for 3 years, and during that time he still was lobbying for a decent court. He was back on the bankruptcy bench, and what had happened was that everybody, all the bar, wanted to change this, wanted to do something, wanted to get something going in 1984. So people converged on Congress. Most of us from our area were supporting Article III judges. Congress just enact a law that amends the bankruptcy code and simply sets up Article III judges, and that will cure the entire problem. So in about 1983 or so, a delegation from Atlanta, along with delegations from all the major cities, went to Washington, and we lobbied Congress. I happened to be one of the people that went up there. There were a number of other folks. Most everybody from what we had previously called the bankruptcy ring went up there, because there were a lot of folks now that practice bankruptcy law outside of the so-called ring. We went up to Washington, and we went to see every congressman or congresswoman. Well, there weren't any from, I think, in Georgia. We went to both the U.S. senators, and we told them, this is what you ought to do. You've devastated this court. You've got to fix it, and you got to fix it right. So one of the things that I remember about that trip, two things I remember about that trip to Washington. The second thing I remember, the first I'll get to. Second thing I remember was I was so glad to get out of there and go back to the real world. That was one thing. That airplane, getting on the airplane at Washington National was something that I really was looking forward to. First thing I remember was going into our Senator Mac, who at that time, one of the two senators was Mac Mattingly. Going into his office, and I remember this because he had this palatial office, and we were sitting in his office. He was sitting kind of in the middle. He'd pulled a chair around, and Neil Batson at that time was our spokesman. So it's all these people crowded into his office, and Neil is telling Mattingly, Senator Mattingly, really, we need to fix this, blah, blah, blah. You just decimated the court, decimated the whole system. We can't have it like that. Article III judges, Article III judges. After he had spoken, a few other people, I think I remember Al Lurie saying something too, and Mattingly said the following, and I'm paraphrasing. I wish I had, I couldn't have recorded it. We didn't have iPhones or anything like that, but I wish I could have. He says, you guys really are very smart lawyers. You really are. And I really appreciate you coming to me. But I would like you to help me. And I'm thinking, and later on Neil said that he thought maybe he wanted help writing something, maybe writing the bill or something like that. He says, I really want you to help me. You know, we have far too many lifetime judges, and we really need to find a way to get rid of them. To which we all looked at each other, turned around, and walked out and hit the nearest bar that we could. And that is actually a true, a real truth. I'm coming to the end of this. In 1984, there was an amendment that set up the current system. The current system, as you know, still gives all the jurisdiction, the pervasive jurisdiction, to the district court, but it has this provision in 28 U.S. Code 157, which says that the bankruptcy judges can exercise can handle cases. It doesn't say anything about jurisdiction. It says they can sit on cases that are so-called core cases, and there is a laundry list of what is core. And then it goes on to say what happens if it's not a core. And if you really look at that and you look at Section 38 of the old Act, you will see a lot of similarities. And you will see a lot of similarities between summary and plenary jurisdiction. And unfortunately, it's there, whether you like it or not. I have always thought that this court of specialist judges should be Article III judges. I doubt seriously in my lifetime that I will ever see it. I agree with Judge Drake and countless other judges and members of the bar that what we ought to have is a court that can handle all bankruptcy-related matters and not just some of the matters. One of the things so the answer to the question, I put a question mark, are we back where we started from? Well, we are in one way of looking at it, and we aren't in another way. And the aren't part is because for the first time, this court is a real court. It's a court of record. It has the judges have law clerks. They have calendar clerks. The administration is handled by a bankruptcy clerk. One of the things I didn't say to you was referees were by themselves. They didn't have anybody. Lawyers generally wrote the decisions for the referees. They were told what to write, and they wrote the decisions because they didn't have any law clerks. They didn't have any calendar clerks. Later on, when the bankruptcy rules went into effect, things changed. But this court is a real court. And there's one other thing, and that is venue. So if you are a trustee, you didn't have to go to Idaho to sue a creditor for a preference. You could sue it right here where the debtor was had residence. I want to leave you with these thoughts from an old war horse who's been doing this for nearly 50 years. And this is what I'd like to leave with you. It has been my experience over many, many years that when you appear before and you have a case before a bankruptcy judge, most of the time, not all of the time, they're going to get it right because they are specialists. They are specialist judges. It's a very important part of it. Why anybody would like to get the reference withdrawn and go to a generalist district court, and I can say this as a senior lawyer, somebody with a lot of age on them, because I'm not, well, I will put that aside. Anyway, I can say this. Why would you want to go to the district court and have the district court sit on a case that they don't understand the law? Perhaps the district judge has just gotten on the bench or has only been on the bench a few years, and more likely than not, the district judge is a former prosecutor who doesn't know a whole lot about the federal rules or about the bankruptcy code. You're going to get a generalist judge opinion. When you go to the circuit court, you're going to have, the specialist, forget all the specialists. There's no specialist. There's no bankruptcy specialist on the 11th Circuit. There is not. Actually, there was a band, and Judge Drake probably remembers the name. I can't remember. There was a gentleman, I believe, from the Northeast who was a bankruptcy judge, and yeah, Judge Sear, who went on the circuit court, right, Jim? Yes. Right, went on the circuit court. Very interesting. In the under the old act in this district, because Chapter 10s had to be decided by the district judge, there were a couple of judges here at district court, judges who were very skilled in Chapter 10s. Judge Edenfield, for example, he really knew Chapter 10. But when you go up from one step to another on the appellate ladder, and you finally get to the Supreme Court from the circuit court, you now have folks who absolutely do not understand day-to-day practice. They don't really know when they decide a constitutional issue what it is going to do to the court, what it's going to do to the public. Now, if you don't care, then you can appeal some of these decisions. You can wait a couple of years. Bankruptcy orders have never had any priority in any of the, whether in the district court or the circuit court, and certainly not in the Supreme Court. I think if we don't have Article III specialist judges, then we ought to stick with what we have, and you ought to think twice before you get the reference withdrawn, and you ought to think twice whether you're going to make it on an appeal to a district court who doesn't understand your issue. You know, if you've ever tried a fraudulent transfer, now called avoidable transfer under the Georgia, the Uniform Act, still called fraudulent transfer, I think, under Section 548. If you ever tried that before a jury in federal court in a diversity action, you're looking at a jury who absolutely does not understand what you're talking about, what the witnesses are talking about. They don't know what solvency means. They don't know what equitable insolvency, legal insolvency. They don't have any idea what you're talking about. And then the worst thing is when you get to the charges that are given by the district court, maybe by a district judge who doesn't understand what a fraudulent transfer is. Thank you very much. I've enjoyed it. I hope you've learned something.